from the supplementary list at 215 under heading for final disposal item 1 WPC 3516 of 2003 along with item 2.
Track of this case. Here, the respondent hearing is the preemptor. The petitioner hearing is the purchaser of the good. Said it was executed on 20/10/1993. It was registered on 93/97. Preemption application filed
Registered on?
registered on 19/9/97. 1997.
You are the preemptor, right? ये सब फैक्ट तो आ ही गया है ना?
नहीं, हमको खाली दो चीज मानना है। एक कल हम वही कह रहे थे। इस केस में the specific case ये था कि the moment we filed the preemption application, thereafter they projected before that their case is that they projected the gift deed that the same was registered on 1/1/1998. This is the case. Now the moment because we have filed the preemption application, now it has come to our knowledge that one gift deed has been executed. Therefore, we filed an application before the LRDC that the person, the donee may be made as a party in this proceeding, as because we are challenging the gift deed at Sam and Farji. This is the case.
As Sham.
Sam and Farji. This is the Sam and Farji document. This plea was taken at the first court by including the donee as a party by filing this matter. This I am saying.
That we find even in the writ petition they say that the plea was taken.
Therefore, I am only saying para 9 and para 11 they have admitted this plea that by filing this matter we have taken this plea and this is there in the writ petition. How it पढ़ देते हैं? para 9 से हम उसको पढ़ देते हैं। ये हो गया। आज का किसी पर हमारा सलाह भी है। That on 11/6/1990 respondent number 5 an application before the respondent number 4 for including the respondent number 9 as opposite party number 6 to the said application. However, in the said application, respondent number 4 did not make any elimination or impeachment the deed gift either on the ground of Sam and the same being 30 or otherwise. Thereafter, para 14, I have also replied that it is stated and submitted that respondent number 5 does not produce any evidence whatsoever to the allegations made in this matter in the that however the respondent number 4 without taking into consideration para 13 that the respondent number 9 also filed a reply to the rejoinder filed by respondent number 5 by way of counter rejoinder and conveniently denied all allegations made in the rejoinder and contented with the allegation. Para 11 that the respondent number 5 filed rejoinder to the subsequent filed by the petitioner and in the said rejoinder para 11 and in the said rejoinder the respondent number 5 for the first time challenged the deed of gift on the ground of some being fraudulent and illegal. So this plea was taken
At the threshold.
Yes. Now, thereafter, LRDC has defined so far as the contention of my learned friend. That deed was registered on 1/1/1998. Therefore, it will relate back to the date of execution. I have no problem. I am also submitting the same fact because in view of the 47 of the Evidence Act, it will relate back. Now the question is as to whether the gift deed was Sam and Farji. This plea was taken. Now I am placing the judgment which my learned friend has placed before this on the report. Page 282. पहला बार कंटेंशन लिया था इसमें पारा 4 का सेकंड थर्ड पारा देखा जाएगा इसमें हम ये द लैंडेड सिंगल जज हैज फेल्ड टू एप्रिशिएट para 4 का third. The learned single judge is failed to appreciate the doctrine of these conditions is not applicable to the facts of such a case as the actual gift deed was given prior to filing of the preemption of case which has specifically been pleaded by the appellant and not denied by the respondent. In this case, the only plea was taken that this was list pending. That and because the deed was registered after the execution, so it was hit by list pending. No summons for the further. The donee was not made as a party in the entire proceeding. Donee was never made as a party.
Donnie was not party.
Not party. इसको आगे पढ़ते चले जा रहे हैं. Now if one can come to para 30 of this para 30. The applicability of provision of section 16 of the Act of 1961 in the facts of this case would be there if the gift deed dated 29/7/1991 will be declared to be sham and forgery. But the said gift deed having been executed on 29/7/1991, which is prior to the application filed under section 63 of the Act of 1961, that is 21/8/1991, the said gift deed cannot be said to be sham and forgery, and as because the law is well settled that in absence of categorical finding or evidence that the gift deed executed on the date of preemption cannot be held to be a forgery or sham document, it has, if the private respondent has failed to establish the above fact, no presumption can go into the said transaction merely because they consigned. In the case of Srimati Premata Devi, the additional member board of revenue Bihar Patna, a divisional bench of the Patna High Court has held that the deed of gift executed before filing of the preemption application but registered during pendency of the application is excluded from the purview of preemption. Such a transaction can be hit by the provisions of section 3 of the Act only if there is an allegation of sham and forgery transaction and the authorities find the allegation true. No, madam. Last para of this 287 page 287 आधा से पढ़ रहा हूँ 287 next page class पढ़ रहे हैं first para छोड़ देना the further admitted fact as has been held by the divisional bench of the Patna High Court in the case of Abdullah Mia Jodhar Rao and others reported in 1997 PSR 371 wherein it has been held that if the applicant claiming preemption did not include the subsequent transfer from the original transferee, although the fact of such transfer was known to him, such an omission is fatal as the subsequent transferee had acquired a status of official transfer. Herein also the daughter of the petitioner has not been included as a party even though out of 0.11 acres of land, 0.01 acres of land has already been gifted in favor of her daughter. Now, and thereafter, other judgments are being quoted where it has been held that it is necessary if there is a subsequent transfer.
Here, who had taken the gift deed?
The daughter. Dhoni was the daughter.
And what was her name?
रागिनी कुमारी.
इसमें हाँ
नहीं इसमें नहीं इसमें ये केस ये जो आप साइट कर रहे हैं. देखिए इसमें पेज नंबर 9 पैरा 9 में in favor of her daughter namely Pramila Devi by virtue of gift deed. Writ order with the Pramila Devi is a party. ये है तो writ order.
हाँ तो subsequent party मतलब last में बनाया पहले नहीं बनाया.
अच्छा शुरू में नहीं
शुरू में
पता एलिगेशन
इसलिए हम पढ़ बता रहे थे इसको पार्टी नहीं थी इसलिए या daughter of the petitioner has not been included as a party even though out of 2.1 acre has been already been gifted in favor of her daughter. नाम अलग से I'm reading इसमें अलग से
Anyway, जो इसमें है हम लोग तो वही देखेंगे.
हाँ
We can't go beyond it. But in the writ petition, Pramila Devi is a party.
हम एक बार चेक कर लेंगे
है तो.
लेकिन हमारा पिटिशन होगा लेकिन वो जो है ना उसमें क्या स्पेसिफिक प्ली में रहा था इसी बात को इंक्लूडेड एज ए पार्टी नाम पार्टी के बाद पिटिशन में पार्टी
पार्टी
बाद
है.
में बनाते हैं तो आपको लगता है कि रीजनल स्टैंड इसको बनाते हैं जो भी बट राइट फ्रॉम वेरी बिगिनिंग वो पार्टी में थी नो फिर नेक्स्ट यहाँ नीचे से पढ़ रहा है नोटिस में कहीं नीचे से पढ़ रहा है The decision of the Patna High Court rendered in the case of Sunil Kumar Chaudhary versus 287 का last part. Wherein the first were to the effect that against the preemption application filed under section 63 of the Act, the procedure to the extent that the land were already transferred by way of gift and preemption was not reasonable because the jury was not made a party. To the preemption proceeding, no step was taken by the preemptor to include the jury before original authority. However, he was included for the first time before the revision court. The Board of Revenue affirmed the claims of preemption on the ground that subsequent duty was fuzzy and fraudulent and was intended to frustrate the claim of preemption. The court, however, held that the claim of preemption was not meritorious because the second transfer duty was not included before the court of first instance, even though the fact of second transfer duty has come in the light of the Supreme Court filed by the vendor. It is not in dispute that the transfer of or gift if found fuzzy, then only the applicability of section 63 of the Act of 1966 one would come, but merely by raising such an issue without leading evidence to that effect and without including only the same will not be sufficient for making applicability of the provision of section 63. Now thereafter, in the case of Rajiv Kumar Prasad and another versus the recent member board of Revenue Jharkhand Patna, it has been held that the right of preemption is a very weak right and the preemptor must make out a foolproof case in order to succeed, whereas such weak and tenuous claim of preemption can be legitimately affected and defeated by a bona fide transaction of gift prior to application. If the document of second sale
So you want to say that here in this case the document was the plea was initially taken.
taken at that
The
time.
donee was made party. The allegation of fudgy or was
further transaction was included and further
and it was found to be true
by the member board of revenue finally
by the member board of revenue.
अब उसके बाद अभी दो जजमेंट खाली हम इसी का कोर्ट दिखा दे रहे हैं ये सारा है कि हम पार्टी शुरू से बना दिए हमारा मूल क्लेम था हम अपने जो ये फाइल किया है काउंटर एफिडेविट इन दैट काउंटर एफिडेविट पारा 18 में हम क्लियरली बोले हैं कि हमारा जो मेन कंटेंशन था टू प्रूव इट वी आर प्रूविंग इट बाय ब्रिंगिंग ऑन रिकॉर्ड द गिफ्ट डीड इटसेल्फ गिफ्ट डीड को हम ला अब गिफ्ट के डीड के जो ये रिसाइटल से हम प्रूव करना चाहते थे कि इट इज अ सामने फर्जी ट्रांजैक्शन नाउ देयरफॉर दो जजमेंट जो है ये ऑनरेबल पावर ऑफ द कोर्ट सुपारा जी लास्ट दो जजमेंट कोर्ट किया है हम यहाँ से पढ़ रहे हैं लास्ट पारा ऑफ केस 288 इट इज सेटल्ड टू पोजीशन ऑफ लॉ दैट व्हाइल एक्सरसाइजिंग द पावर ऑफ writ of certiorari the writ court is to consider the fact on the ground of lack of jurisdiction or purpose case 288 का लास्ट power of writ of certiorari the writ court is to consider the fact on the ground of lack of jurisdiction or perversity in the finding within its limited scope. At this juncture, it will be proper for this court to refer the judgment rendered by the Honorable Apex Court in case of Sayyid Yaqub versus Radha Krishnan and others reported in the Supreme Court, wherein at paragraph 7, their lordship have been pleased to hold as follows. The question about the limits of the jurisdiction of the High Court in issuing the writ of certiorari under Article 226 has been frequently considered by this court, and the true legal position is that in that behalf.
That's right. It's a very limited.
It is very limited.
Finding of fact cannot be.
And finding of fact. And now we have also by filing though they have brought on record annexure 2 is the gift deed, and we have also brought the same gift deed. Further, we have also annexed one parcha wherein they have said that on that very date there was a strike in registry office. They have got the information that there was no strike and the documents were registered. But because I am not on that point, because it will relate back to the date of execution, so my only submission before this board.
Since there is a finding of fudgy.
Fact that it can't be termed as it is a gift.
So this authority has got the jurisdiction to examine as to whether
Yes,
the deed is fudgy or not.
बस
वो jurisdiction है,
हाँ,
क्योंकि उसके बिना कैसे decide होगा?
उसके लिए अगर वही ऑफ जजमेंट लाया डिवीजन बेंच
नहीं,
क्या कि वेदर
examine नहीं करेगा तो फर्जी कैसे
डिसाइड
करेगा?
कैसे करेगा? वही है अभी इसका हम पारा इसमें था कि इसमें एक प्ली किया गया कि पैसा ही नहीं दिया, मतलब वेंडर को हमने पैसा नहीं दिया।
इसमें था कि पैसा देकर गिफ्ट हुआ।
गिफ्ट हुआ।
इसमें है कि ये
हाँ,
जो लेडी जिसके फेवर में गिफ्ट हुआ है,
हाँ, वो पैसा
she is the person who had invested for the purchase, और वो पैसा देने के बाद गिफ्ट हुआ, तो ये गिफ्ट जो है is passing, there is a consideration passing through this gift deed.
It is not a gift.
तो यही है,
डॉक्यूमेंट का कंस्ट्रक्शन
ये फाइंडिंग ही है।
और इसमें ये जो अभी ऑर्डर
ये क्या है इसमें?
जो ऑर्डर प्लेस करें इसमें ये था कि वन प्ली वाज टेकन कि सपोज अ ट्रांसफर वाज मेड एंड डीड वाज रजिस्टर्ड एंड इफ समवन टेक द प्ली दैट कंसिडरेशन मनी हैज नॉट पास्ड एंड देयरफॉर द लैंड वाज नॉट ट्रांसफर्ड टू द ट्रांसफरी, whether in that case if that plea was taken whether presumption can be allowed or whether the court is justified in
एंट्री हाँ कहाँ पर
इसका पारा नहीं देखा है। I am not impressed by the third point urged on behalf of the petitioner either. The proceeding before the revenue court under section 63 of the Act is not a summary proceeding as the expression is generally understood. Within its scope, it is a full-fledged proceeding subject to the right of appeal to the aggrieved party under section 30 of the Act and the revisional power of the Board of Revenue under section 32. Section 43 bars the jurisdiction of the civil court to settle, decide or deal with any question which is by or under the Act required to be settled, decided or dealt with by the Board of Revenue, the Commissioner, the Appellate Authority or the Collector. If it were to be held that the question raised by the transferor that there was no transfer of land by him, whatever may be his ground for saying so, was not to be dealt with or decided by Revenue Court in a proceeding under section 63 of the Act, it will lead to anomalous results and multiplicity of litigation. In a civil court, it will be open to the transferor to raise the same question because in the event of section 43 will not be a bar. If the civil court decides the matter in favor of the transferor, the entire proceeding under section 63 and all the orders passed therein will be set at naught. It does not seem to be either obligatory or expedient to take the view as urged on behalf of the petitioner, rather the scheme of the Act and rules suggest that all relevant questions which can be raised either by the transferor or by the transferee should be raised before and conclusively settled or dealt with by the revenue court, so that the jurisdiction of the civil courts may be barred. And thereafter, matter parity. So power is there with the court.
तो एग्जामिन ऐसा तो नहीं है ना कि एग्जामिन नहीं करेगा, एग्जामिन करेगा तो फाइंडिंग देना ही होगा।
फाइंडिंग देना, अब उस इसमें हम गिफ्ट डीड हजूर के सामने भी ले आए, एक्सेप्ट टू के पेपर में आए, हम ऑर्डर एफिडेविट भी ले आए, अनडिसाइडेड इज देयर।
कहाँ है रिसाइकिल गिफ्ट?
पेज 29 एनेक्सर के रीड पिटीशन का पेज 29 मैं दो तीन लाइन नीचे से पढ़ा दूँ दाखिल चली जाती है कि ये देखेदारी मेरी पुत्री है जो साथ में रहती है, वो सेवा शुश्रूषा करती आ रही है और वो हम जमीन को खरीदने के लिए रुपया कुछ रकम बाद अपने पास से लगाए, जो चूँकि यह जायदाद खरीदने के लिए लेगेदारी का स्थिरीकरण रकम लगा है और रकम लौटाना लाजमी है, परंतु लेगेदारी सेवा शुश्रूषा करने की वजह से लेगेदारी और उनके पति दोनों यानी माता पिता और भूमि और निवासी मकान की धारी के नाम से प्रदर्शित होते हैं। 25,000 का प्रॉपर्टी था 10,000 हो गया।
The finding of the revision court based on the recital in the deed is based on the recitals. There is no perversity.
No perversity.
वैसे डिवीजन बेंच का जजमेंट अभी अपील में सुप्रीम कोर्ट में पेंडिंग।
हाँ वो हमको पता है। अभी पहले हम तुरंत चेक भी कराए थे, इट इज स्टिल पेंडिंग।
इट इज स्टिल पेंडिंग। कल हम लोग निकाले थे, इट इज स्टिल पेंडिंग।
अभी हम तो हम भी चेक कराया थे।
ये पता नहीं चल रहा है ये प्रमीला देवी कब पार्टी बनी है, क्योंकि ऐसा कुछ पता नहीं चल रहा है, क्योंकि शी इज पार्टी।
पार्टी
चलिए, आपको क्या पता?
For 13 of the petition.
आप जाइए और पंकज जी को भेज दीजिए, पंकज जी को भेज दीजिए। पैरा 13।
Yes. So far as Sam in Fergie is concerned, Roshi, the respondent number 9 also denied Roshi. The respondent number 9 also filed inquiry to the regional file by respondent 5.
डिनाई किया, लेकिन फाइंडिंग हो गया ना। अब डिवीजन बेंच बोल दिया है कि एकदम परवर्सिटी के बिना तो हम नहीं देख सकते। तो आई विल कोट दैट आई कैन नॉट सी।
So far as Sam.
You get the order from the division bench only. भाई उतना क्लियर ऑर्डर है कि हमको जुरिस्डिक्शन नहीं था उसको देखने का, क्योंकि देयर इज इन एब्सेंस ऑफ परवर्सिटी।
So far as
तो
Sam.
226 का स्कोप को क्लैरिफाई कराइए डिवीजन बेंच।
So far as Sam in Fergie is concerned, which is required to take evidence. But where is the evidence?
No,
I am
where is
putting
the
it-
evidence? What do you mean where is that? The gift deed itself is the evidence. It is mentioned in the gift deed that there is a transaction of money and she was to be repaid.
Then after I prayed also this case will be taken up to this.
नहीं, not required. Not required. हम तो उसी से लिख देंगे कि pending है सुप्रीम कोर्ट में. But in view of this judgment also, by the division bench also, the case is covered against you. It is not in your favor. Because the division bench says that if the transaction is found to be forgery, then under such circumstances, Section 3 will apply. Simple. हम लिख देंगे आपका पेंडिंग है सुप्रीम कोर्ट में, ये सब हम लिख देंगे। एक में तो डोनी इज द पिटिशनर,
Petitioner.
एक में द
Purchaser.
परचेजर इज द पिटिशनर। Appellant is the preemptor. The petitioner is the
Petitioner is
preemptor.
the purchaser.
Okay, sorry.
Respondent 5 is the preemptor.
एक सेकंड, रागिनी कुमारी
Ragini Kumari.
Is the Dhoni?
Dhoni.
एक सेकंड, रागिनी is Dhoni who has filed WP C number 353 03, right?
जी.
और ये जो पिटिशनर है दूसरा उत्तम राज देवी,
She is the purchaser.
purchaser WPC number 3516. Private respondent preemptor
Respondent number 5.
in both the cases.
Yes, both the cases.
You are the adjoining player or the co-sharer?
He is the co-sharer.
You are the adjoining
Co-sharer
player?
and adjoining player.
Both
Three sides.
Only on the ground co-sharer. Not the adjoining player. Lord, we can you see?
Co-sharer, that is not the dispute. ये तो कोई बहस ही नहीं है. Entitlement तो है ही, co-sharer हो चाहे
Co-sharer.
adjoining player, तो इससे कोई फर्क नहीं.
They have the petition claim किया कि तीनों साइड से मिलेंगे.
हाँ, बुलाइए.
दोनों co-sharer adjoining player. दोनों.
और seller कौन है?
Seller है कोई respondent number.
Six, seven, eight. Vendor?
6, 7, 8.
तीनों ने सही किया है. तीनों ने बेचा है.
हाँ, तीनों भाई हैं.
तीनों एक साथ बेचे हैं.
हाँ, एक साथ. एक साथ.
पंडित जी कल आपको चेम्बर में
जी।
चाहिए थे, अपॉइंटिंग लिखिए. पहले इनका आर्गुमेंट लिखिए. The learned counsel for the respondent representing the respondent number 5 has submitted that he is the preemptor. He has submitted that there is no doubt that the gift deed which was registered on 1/1/1998 would relate back to 18/11/1997, which is the date on which the deed was executed and presented for registration. He submits that in spite of this fact, in spite of this, the fact remains that as soon as it came to light to the preemptor that the property has been transferred through gift, appropriate amendment was carried out and the donee was made party in the proceedings. And at the initial stage, that is before the authority deciding the proceeding under section 16 within bracket 3 of the aforesaid Act of 1961, a stand was taken that the gift deed was collusive and sham and forgery. Sham and forgery. The learned counsel submits that the authority had given a finding that the deed was sham and forgery and allowed the preemption application. So far as the appellate authority is concerned, the order was set aside. The revisional authority, that is before the member board of revenue, after considering the materials including the gift deed itself, recorded that the transaction of gift was sham and forgery. He submits that in such circumstances, the judgment which has been relied upon by the learned counsel for the petitioner, reported in 2021 1 JBCJ 278, is actually in his favor. He submits that it has been held in the same case that the gift deed would, upon registration, would relate back to the date of its execution. But if the transaction is found to be sham and forgery, then the petition under section 16 with bracket 3 of the Act of 1961 is to be allowed. He has further referred to the said judgment and has submitted that the Honorable Division Bench has also considered the scope of Article 226 of the Constitution of India and has held that it is settled position of law that by exercising the power of writ of certiorari, the writ court is to consider the fact on the ground of lack of jurisdiction or perversity in finding being its limited scope. The Learned Counsel submits that since the finding of the Learned Member Board of Revenue that the gift deed was sham and forgery is based on material, the same cannot be interfered, may not be interfered in writ jurisdiction. And therefore, this writ petition is devoid of any merits.
But DCLR के order में sham
Yes.
फर्जी नहीं है.
He has also submitted that the Honorable Division Bench has also taken note of the fact that in the connected writ, the daughter of the writ petitioner who was gifted the property was not impleaded in the proceedings. Correct? He has also submitted that the judgment is in his favor and therefore the writ petition is dismissed. At this, the Learned Counsel for the petitioner who has cited the aforesaid judgment reported in 2021 within bracket 1 JBCJ 278 has submitted that one SLP has been filed against the same, being special leave petition within bracket civil bracket close diary number 25302 of 2022 before the Honorable Supreme Court, which was lastly listed on 29/2023. Submits that the matter is sub judice before the Honorable Supreme Court. To this, the Learned Counsel for the respondent has submitted that there can be no dispute that if the gift deed is found to be forgery, then under such circumstances, the petition for preemption is to be allowed. And such finding was based on numerous decisions, previous decisions of the court, which has been referred to in the judgment passed in the LP. After hearing the Learned Counsel for the parties, this court finds that the petitioner in WPC number 3516 of 2003 is the purchaser of the property and the petitioner in WBC number 3532 of 2003 is the donee to whom the purchaser had gifted the property. The vendor of the property are respondent numbers 6, 7 and 8. The respondent number 5 is the preemptor. The foundational dates are also not in dispute. The purchaser had purchased the property on by way of registered deed, the registered sale deed, which was dated 20/10/1993 and was registered on date ध्यान दीजिएगा, which was dated 20/10/1993 but was registered on 19/9/1997.
No, 16/9/1997.
Registered on 16/9/1997. The petition for preemption under section 16 within bracket 3 of the aforesaid Act of 1961 was filed within the period of limitation, that is on 10/12/1997. After filing the petition for preemption, it was based on record that the property was already transferred by the purchaser to the donee by virtue of gift deed, registered gift deed dated 18/11/1997, registered on 1/1/1998.
उनके कहना है कि 29/9/97 को वो एक्सिक्यूट हुआ, 18/11/97 को प्रेजेंट हुआ रजिस्टर के पास और रजिस्ट्रेशन
Excellent. Deed was executed on
29/9/97
29/9/97, presented before the registry for registration on 18/11/1997.
कहना मुझे स्ट्राइक था तो
That's right. And it was ultimately registered only on 1/1/1998. The deed was registered during the pendency of the application of preemption. It is not in dispute during the course of argument that the deed of registration of the gift deed would relate back to its execution. That is 29/9/1997. Correct? In view of section 47 of the
Indian Registration Act,
Indian registration.
a sale deed would be operated from the date of its
That's-
execution.
That's right. It is also not in it also appears from the records of this case that before the authority dealing with the petition under section 16 within bracket 3 of the aforesaid Act of 1961, the donee was made party and she appeared before the court and contested the proceedings, and the preemptor had made an allegation that the gift deed was sham and forgery. This court finds that the authority returned a finding that the gift deed was sham and forgery.
By the DCLR also.
Yes.
No, there is no finding.
DCLR का कहना है कि
नहीं, कोई finding नहीं है. वही तुम बोलिएगा. मैं पढ़ दे रहे हैं, कोई finding नहीं है.
इसका कोई finding
नहीं, sham and forgery कोई finding. DCLR कोई finding ही नहीं है. पढ़ लेते हैं फिर एक बार.
लीज पेंडेंस को करके रिजेक्ट
हाँ लीज पेंडेंस बोला सैम फर्जी नहीं बोले वो बोल रहे हैं
फाइनली मेंबर बोर्ड ऑफ
Okay. It is not in dispute that इसको last line हटाना चाहिए. That the preemption application was allowed by the authority against which the appeal was allowed, and ultimately the matter came up before the member board of revenue. In the revision filed by the preemptor.
preempt
And two sets of दो रिविजन फाइल हुआ था.
हाँ, दो रिवीजन फाइल हुआ था दो अपील भी फाइल हुआ था एक उत्तम राज देवी की तरफ से एक रागिनी की तरफ से
Before the appellate authority, two appeals were filed.
both
One by the purchaser and other by the donee.
donee.
And before the revisional authority also, two revision applications were filed. And they were numbered as case number 31 and 32 of 2002, which were decided by common judgment, which is included in the present proceedings. The member board of revenue considered the
para 52
para.
पर पेज 52 का है.
Just a moment. The member board of revenue was of the view that member board of revenue had referred to the judgment the judgment reported in 1985 BLJ 697, Srimati Priyambada Devi and another versus additional member board of revenue. And observed that in the said ruling, it was also laid down in the said ruling, it was laid down that Section 16 within bracket 3 of the Act of 1961 will not be applicable to gifts of land. But in the said ruling, it was also laid down that the gift must fulfill the condition that it was not challenged as sham and forgery. The member board of revenue closely examined the gift deed and found that the gift deed was sham and forgery, and the recital of the gift deed itself revealed about repayment of the fund invested by the purchaser of the land
by the donee.
purchaser of the land, and such refund was being made by the donee, and observe that the gift deed referred to a consideration in its recital. the authority also observed that it was evident that the so-called gift deed was drawn up to defeat the provision of the Act of 1961, as the opposite party number one was well aware that she was not the adjoining rayat of the disputed land, and held that the gift deed was sham and forgery. The authority ultimately set aside the appellate judgments and decided the case in favor of the plaintiff. The learned counsel for the respondent has relied upon the judgment passed by Honorable Patna High Court reported in 1972 SCC online Patna 189, and has referred to paragraph 9 of the same judgment to submit that the authority had the necessary jurisdiction to examine the fact as to whether the gift deed was sham and forgery, and such exercise has been rightly taken up by the authority. Paragraph 9 of the aforesaid judgment is quoted as under. The finding of this court finds that the fact that the gift was sham and forgery is based on materials on record, and the finding cannot be said to be perverse, nor it is the case of the petitioner that the impugned order passed by the Member Board of Revenue is without jurisdiction. In the judgment passed by Honorable Division Bench reported in 2021 within bracket 1 JBCJ 278, the Honorable Division Bench has clearly observed that it is settled position of law that while exercising the power of writ of certiorari, the writ court is to consider the fact on the ground of lack of jurisdiction or perversity in the finding being its limited scope. A reference has also been made to numerous judgments with regard to the scope of Article 226 by issuing a writ of certiorari, and a reference has been also made in the judgment passed by Honorable Supreme Court in the case of Swern Singh and another versus State of Punjab and others reported in bracket 1976 bracket 2 SCC 868, whose relevant paragraphs have been quoted as under. The same have been quoted. The same are being also quoted as under. Considering the limited scope as laid down by the Honorable Division Bench, this court has no doubt that the finding of fact recorded by the learned Member Board of Revenue that the gift deed is sham and forgery does not call for any interference. Further, from the aforesaid judgment itself, it is apparent that the court had recorded that the donee was not made party, and has also recorded that had also referred to the judgment passed in the case of Srimati Priyambada Devi Supra, reported in 1985 PNGR 662, that wherein it has been held that the gift deed executed before filing preemption application but registered during pendency of the application is excluded from the purview of preemption. But such a transaction can be hit by the provision of section 16 within bracket 3 of the Act only if there is an allegation of sham and forgery transaction and the authorities find the allegation true. The relevant extract from the judgment passed by Honorable Division Bench in paragraph 12 is paragraph 13 is quoted as under. The aforesaid observation of the Honorable Division Bench this court finds that the law appears to be well settled by now, that a transaction can be hit by the provision of section 16 with bracket 3 of the Act in connection with gift is hit by the provision of section 16 with bracket 3 of the Act of 1961 only if there is an allegation of sham and forgery and transactions and a forgery transaction and the authorities find the allegation true, and in the present case as held above, the allegation that the gift deed was sham and forgery has been found true by the revenue authorities. By the member court of revenue, which is a final court of fact. This court is of the view that merely because SLP has been filed, who has filed the SLP? The preemptor. Merely because SLP has been filed by the preemptor against the judgment, against the FOC judgment, and the same is pending, the same will have no bearing in the present proceedings. Till date, as it appears from the order sheet of the Honorable Supreme Court, no leave has been granted. So, in view of the aforesaid facts and circumstances, this court finds no merit in this petition, which is hereby dismissed.
एक लाइन सबमिशन लॉट से इस परमिट लॉट वन लाइन
आपका सारा सबमिशन
एक है कि DCLR जो है वाज नॉट डिक्लेयर द गिफ्ट डिड इज सैमन
इससे क्या फर्क? हम तो बोले एक अलाउ किया, एक डिसमिस
एक
किया।
लाइन में सबमिशन लिखा गया है कि DCLR वाज नॉट डिक्लेयर द गिफ्ट डिड इज सैमन फर्जी, वो एक लाइन मेरा सबमिशन में
The counsel for the appellant as petitioner has submitted that the original authority dealing with the petition under section 16 within paragraph 3 did not declare the gift deed sham.
सैमन ओब्ले
From daily list, under heading for final disposal item 1, WPC 1131
अब जाइए जिसका
लास्ट केस में स्टेट की तरफ से नॉन अपीयरेंस रहेगा क्या?
आज तो
कोई नहीं था परहैप्स।
स्टेट की तरफ से कोई नहीं है, लेकिन कल तो थी।
तो
किसी का अपीयरेंस मेमो आए तो डाल दीजिए।
In this case will not be what question which is involved. But before that, I just point out that the This honorable court directed issuance of notices to all the persons now through state, and state has filed a counter affidavit on the affidavit that notices have been served. Because of the fact that the councils whose names were appearing from 3 days when they didn't appear, therefore this order was passed, and pursuant to the order, they have filed a counter affidavit, supplementary affidavit, service of notice upon the respondent. This is one. Now, in this case, your lordship will find, Lord, that a permission under section 49 of the CMP Act was granted in favor of the original petition. And after permission granted under section 49, then Lord, they filed an application under section 71.
Just. Two has been substituted.
Yes, that is. Names have been added. You will also just see the order dated 20th March 2023.
20th March.
Yes, Lord. Order number 26. That has been carried out. Response number 9 and 10.
9 and 10 का बात नहीं करनी.
सब्स्टिट्यूशन जो
Petitioner number 2 का बात करना.
यस, इसका तो पिटीशन दिया है 30/6/25. आईए नंबर 8171 of 2025.
Okay. ठीक है.
Now,
बताइए.
just summary. An order under section 49 was passed granting permission of transfer of the land in question by Annexure 1. That is dated 19th February 1982. If Lordship may kindly see for a moment this permission note Annexure 1, page 22 of the writ petition below. By the Upper Upayuk, Additional Deputy Commissioner, Singhbhum Chaibasa. That the applicant was Chetan Devgam, Pita Sachensa, and Ramchand Prajapati, the original petitioner mirror. Sachensa, Chanchaladev Sachensa, जांच प्रतिवेदन से स्पष्ट होता है कि खतियानी दैयत की मृत्यु हो गई है। आवेदक गण खतियानी दैयत के उत्तराधिकारी है। आवेदित जमीन खेती का लायक नहीं है, पड़ती है, तथा उस जमीन के विक्रय के प्राप्ति के राशि के आवेदक उन्नयन कराएंगे। विदित जमीन पर क्रेता कपड़ा बनाने का प्रयोजन करेंगे, जिससे 15-20 व्यक्तियों को नियोजन होगी। आवेदक का विद्वान अधिवक्ता को सुना। अंचल कर्म अधिकारी एवं जांच प्रतिवेदन के आधार पर आवेदक चेतन देवगाम, पिता सचन थाना नंबर 641, खाता नंबर 8 का प्लॉट नंबर 114 का 12 डिसमिल जमीन श्री रामचंद्र प्रजापति सचन स्थित छोटनापुर सेक्शन 49 के अंतर्गत हस्तांतरण की स्वीकृति दी जाए।
आगे आवेदक निबंधन के पूर्व क्या
निबंधन के पूर्ण काम
टर्म्स ऑफ सेल
से प्रस्तुत
टर्म्स ऑफ सेल प्रस्तुत करें।
That is one of our secret. The terms of sale deed next line 15/82 registered sale deed was produced and it was also approved. Now this land was obtained, acquired by the original petitioner by virtue of a permission under section 49. Why I am pressing. Now, after lapse of so many years, an application under section 71 capital A was filed.
Who filed it?
By the legal heirs, one Pushkar Hembram, Chetan Hembram filed. Now that's
Just a moment.
That is an excerpt to page 24.
Son of
Chetan Hembram himself.
who was the applicant here?
Yes,
He was also the applicant.
yes. He was the applicant, sole applicant. For seeking permission.
चेतन
Hembram.
हेमब्रम तो नहीं,
Chetan Devgam, sorry.
देवगम। और यहाँ पे कौन किया?
वो चेतन देवगम.
चेतन देवगम।
Yes, same person. Now, the lordship may consider 118 one CWJC 1263 of 1987 R was filed by the original petitioner.
CWJC number
CWJC 1263
1263.
of 1987. Upon
1987.
receipt of the notice was sent.
Okay.
This honorable court said that you raised the issue of jurisdiction and the court was directed to decide the jurisdiction because the maintainability of section 71A CNTF was questioned. Now, the lordship may kindly see below.
Where is that order?
That order is not on record, but it is referred in the original order where dealt with this case. I will just read it, but I am just summarizing the facts first. Then I will also bring your lordship's notice note of these facts. Then on 11/4/1988, a restoration order was passed.
CWJC 1263 of 87.
11/4/1988, Annexure 2, page 24. The order of restoration was passed under section 71A. Now, lordship may kindly see Annexure 2, page 24.
This is SAR case number.
SAR case number 1/1987-88. The lordship just see for a moment what I submitted to lordship. Page number 26. Page 26 will be there. Has the lordship got it?
Yes.
परंतु यह भी स्पष्ट किया है धारा 49 के अंतर्गत दी गई अनुमति के शर्तों का उल्लंघन होता है तो उसके लिए धारा 49/71A के अंतर्गत कार्रवाई का प्रावधान नहीं है। इस ही आधार पर प्रतिपक्ष ने माननीय उच्च न्यायालय में एक याचिका दाखिल की थी जिसके अंतर्गत यह आदेश दिया गया है कि संबंधित मामले में पहले कार्यक्षेत्र की संबंधी उठाई गई बिंदु पर सर्वप्रथम विचार किया जाए यदि इस संबंध में प्रतिपक्ष के द्वारा आपत्ति प्रकट की जाती है। So we raise this point because and that has been quoted what I submitted to lordship. Then your lordship may kindly see next paragraph. छोटनागपुर काश्तकारी अधिनियम के धारा 71 के प्रावधान इस बिंदु पर पूर्णतः स्पष्ट है यथा यदि किसी समय उपायुक्त को पता चले कि विपक्षी रैयत की जो अनुसूचित जनजाति के सदस्य हैं भूमि के अंतरण धारा 46 या इस अधिनियम के किसी अन्य उपबंध का उल्लंघन करने का पर वादी में कपट या दुर्संधि द्वारा प्राप्त डिग्रियों सहित किसी कपटपूर्ण ढंग से दिया गया है तो अंतरण जो वो दखल किए जाने वाला है सफाई देने के उपयुक्त अवसर प्रदान करने के बाद इस विषय के आवश्यक जांच कर लेने के बाद अंतरिता के प्रतिवादी के भुगतान किए बिना ऐसी भूमि से दखल कर सकेगा यह भूमि 71A को जो हिंदी में कोट इस प्रकार धारा 71A के प्रावधानों के अंतर्गत यह स्पष्ट है यदि अंतरण धारा 46 तथा इस अधिनियम के अन्य उपबंधों को यदि उल्लंघन कर कपटपूर्ण तरीके से अनुसूचित जनजाति का जमीन का अंतरण करा लिया जाता है तो धारा 71A के प्रावधानों के अनुरूप पक्ष न्यायालय कब्जा वापस दिलाने हेतु सक्षम है। So he held that he has jurisdiction to entertain a proceeding under section 71A even in respect of land which was permission was granted under section 49. That is the finding.
In case of violation. In case of violation.
In case of violation. But no finding with regard to violation. That is the law position has been because the honorable court directed him to decide the jurisdictional issue. So therefore he decided that he has the power. Now next paragraph.
नहीं ये नहीं उपयुक्त संदर्भ में you see this was to be for the purposes of the purpose was to set up a mill.
Yes, yes, I'm
Now उपयुक्त संदर्भ से एक सेकंड प्रतिवादी के द्वारा कारण पृच्छा दाखिल किया गया है जिसमें यह स्वीकार किया है कि संबंधित भूमि के एक क्षेत्रफल में मकान बना रहे।
पहला तो क्वेश्चन है कि क्या 71A में डिसाइड किया जा सकता है इसके लिए हम ये क्वेश्चन उठाए और it is supported by judgment. I will just cite. Then you will see my kindly see page 27, the finding part. अंचल अधिकारी सदर ने प्रतिवेदन तथा प्रतिवादी के द्वारा दाखिल किए गए कारण की इच्छा को यह स्पष्ट है कि प्रतिवादी संबंधित भूमि पर लिया प्रयोजन के लिए उन्होंने जमीन खरीदी थी, उस उपयोग में उस जमीन को न लाकर मकान बनाने रहे हैं। अतः यह प्रमाणित होता है कि प्रतिपक्ष ने कपटपूर्ण तरीके से जमीन को अंतरण कराया है। ऐसी स्थिति में संबंधित जमीन पर वादी को पुनः कब्जा वापस दिलाने का आदेश दिया। Then it was challenged before the appellate authority. Lordship may kindly see the order Annex 3, page 28. This was affirmed. Lordship may kindly see, this is appellate authority affirmed. I am not reading it. Then your Lordship may kindly come to Annex 4, page 30.
Yes.
We challenged it before the commissioner in revision. That revision was allowed. Lordship may kindly see paragraph 2. It is an admitted position that the land in question have been transferred to the petitioner after obtaining the permission under section 49 of the CNT Act. Revenue miss case number such and such, it has been held by the Honorable High Court in a reported decision 1990 BLT such and such that where the lands have been transferred after obtaining the permission under section 49 of the CNT Act, the provisions of section 71A of the CNT Act are not applicable, and the remedy lies under section 49(5) of the CNT Act. Under section 49(5) of the CNT Act, it is the state government. This is very basic difference between the two sections, which have been held by this honorable court. 171A, it is for the party to file an application for eviction on the ground of fraud, and section 49, in case of 49, I will just read the provision also. 49(5) says it is for the state. So the application of a private party is not maintainable, and that has been held. Then you will also make an decision. It is the state government who can set aside the transfer of the permission. So the order of permission has to be set aside.
No. You see, it is one thing to say that the permission was taken for a particular purpose and the land was not utilized for that
In
purpose.
such case,
Therefore, permission does not become bad. What becomes bad is the use of the land.
consequential effect.
Naturally.
Now, therefore, my submission to Lordship would be that 49(5) is the special provision for that, and the difference between the two, yes, that is the finding.
That's where is
Held
that
by-
judgment? BLT?
Now it is well settled, the provisions of section 71A of the CNT Act are not applicable where the lands have been transferred after obtaining the permission under section 49 of the CNT Act. The learned courts below have wrongly passed the order prayer of the restoration of the land to the opposite party. Then below, the matter was brought before this honorable by the original applicant, Annex 5, page 33.
It was remanded
Yes,
because it was an ex parte order.
expert, yes. That is the reason I wanted to bring your lordship notice that the notice is served upon the respondents here in this instance. This question may not arise in future. Then your lordship again the matter was remanded to the commission. Annex 6, page 35. In which your lordship just see the next commissioner, page 26. आवेदक का इस कथन से सहमति है कि विशिष्ट प्रावधान के तहत सामान्य प्रावधान के तहत
Page number 35, Annex 6 ना?
हाँ, Annex 6, page 36 पढ़ रहा है, 35 से स्टार्ट हो।
हाँ ठीक है। आवेदक
का कथन से सहमति है कि विशिष्ट प्रावधान के रहते सामान्य प्रावधान के तहत कार्रवाई नहीं की जा सकती। आवेदक के विद्वान सरकारी अधिवक्ता कथन से कांड में सरकारी अधिसूचना उपायुक्त सिंधु द्वारा निर्गत हुए आदेशों का फोटोकॉपी प्रस्तुत की, जिनके द्वारा जमीन पर तत्कालीन अपर उपायुक्त को छूटना CNT Act के तहत शक्तियां सौंपी गई है। इन सभी अधिसूचना आदेशों का तत्कालीन अपर उपायुक्त के नाम से शक्ति प्रत्यापन किया गया, प्रत्यायोजन हुआ। यह सभी अधिसूचना आदेश 1982 अर्थात उपर समाता के विचाराधीन आदेश के वर्ष के बाद के इनसे यह प्रमाणित नहीं होता है कि तत्कालीन अपर उपायुक्त संगत शक्ति थी। अधिनियम के प्रावधान के अनुसार उपायुक्त की शक्ति का प्रयोग करने की सक्षमता के लिए राज्य सरकार के प्राधिकरण का या उपायुक्त के द्वारा शक्ति का हस्तांतरण आवश्यक है। अभी तक ऐसा कोई सबूत पेश नहीं कर सके जिससे प्रमाणित हो सके कि अधिनियम धारा 49 के सहमति देने के लिए तत्कालीन अपर उपायुक्त प्राधिकृत है। ऐसी स्थिति में माना जाएगा प्रस्तुत मामले में ऊपर सहमति अनाधिकृत थी एवं ई हस्तांतरण शुरू से ही अवैध है। He diverted the issue in another manner. The earlier one 71 है। आवेदक द्वितीय पक्ष के कटी रैयत होने के दावे को भी कोई काट प्रस्तुत नहीं कर सके। अधिनियम के धारा 49 के अंतर्गत ऑक्युपेंसी रैयत और भूमियारी परिवार के सदस्य जमीन का हस्तांतरण कर सकते हैं। मुंडारी कुटी रैयत का उल्लेख भी उसमें नहीं है। इस दृष्टि से भी वस्तुगत जमीन का हस्तांतरण अवैध है। He decided another point, that the permission which was granted was not illegal. Therefore, now, the Lordship may kindly see the 8 by 1. First of all, page 46, Annexure 8. Annexure 8. This is the notification. Dated 12th May 1981.
So he digressed from the main issue.
Digress from the main issue. Number one. Number two, your Lordship may kindly see for a moment what I was arguing. It is supported the judgment what came from your Lordship. I take 1990 BLT page 362 which has been done. It's very short judgment, division and judgment of this one.
आपके पास BLT है?
इसका तो मैं फोटोकॉपी करा है मेरे पास। इधर के पास भी होगा।
मेरे पास है।
मिस्टर पीके सिन्हा सीनियर एडवोकेट के सिलसिला बहुत यूडीसी जे बीएलटी उसका जो एक था बिहार लॉ जजमेंट
वो भी है। मेरे पास रखा हुआ है, सोचते हैं कि लाइब्रेरी में दे देंगे।
नहीं, बहुत अच्छी बात। जो इसका देखा जाए पैरा 13 बहुत शॉर्ट में बहुत सन क्वेश्चन डील किए हैं। जो लोग जस्ट सी पैरा 5 फर्स्ट पैरा the only question involved in this writ petition is in view of the fact that the Deputy Commissioner had recorded permission for transfer of a part of the Rayati land holding to the recorded Rayat in favor of the petitioner, and in pursuance of that the said deed was executed. Whether the application under section 71A was maintainable or the Rayat would have filed an application under section 49(5) of the Act. This is the question. Now, Lordship may kindly see the section 71A has been dealt in para 6, 7, para 7, note 41, 49, 1 has been dealt. Then para 8 comparison between both the provisions have been dealt. Now, submission. Lordship may kindly see para 9. Para 9. It is true that under both these sections, provisions have been made for restoration of the land. But the scope of two provisions are different. So far section 49(5) is concerned, power has been given to the state government to annul any transfer made with the consent of the Deputy Commissioner if it is found that the consent has been obtained for non-contravention in contravention of the provisions of subsection 1 and 2 by misrepresentation or fraud. Under this section, this forum is the state government, and what is required to be determined by the state government is whether cannot consent of the Deputy Commissioner had been obtained in contravention of the provision of subsection 1 and 2 by misrepresentation or fraud. If the consent of the Deputy Commissioner was not obtained by misrepresentation or fraud, there is no question of annulling the transfer. Subsection 1 and 2 of section 49 of the Act report कर दी, इसको हम नहीं पढ़ रहे। 10. It will be noticed that subsection 1 begins with a non-obstructive clause. A Rayat may transfer his holding or any part thereof for any reasonable and sufficient purpose. What is reasonable and sufficient purpose has been mentioned in subsection 2. Even if reasonable and sufficient purpose existed, the transfer must be made by a registered instrument with the written consent of the Deputy Commissioner as provided in subsection 3. Section 71A provides for restoration of land if the transfer has been made in contravention of section 46 or any other provision of the act or by fraudulent method, including decrees obtained by ensued by fraud. The forum under section 71A of the act is the deputy commissioner, although in both the sections the word fraud has been used, whereas section 49(5) is referable to subsection 1 and 2 of that section. In section 71A is referable to fraudulent method. Regulation 1 of 1959 came into force in February 1969. Section 49(5) was introduced in 1976. It must be presumed that legislature knew that Section 71A had been introduced in 1969, empowering the Deputy Commissioner to pass order under certain circumstances. Yet, the legislature inserted subsection 5 of Section 49 for the first time in 1976. This indicates that the scope of 71A and 49(5) are completely different. The, the former speaks about fraud on the transfer layer, whereas the latter speaks about misrepresentation or fraud on the deputy commissioner. In section 49(5), the reference is to subsection 1 and 2 of section 49, whereas in subsection 71A. Section 46 has been specifically mentioned. It is general rule of interpretation of statute that what special provision will override the general provision. When there is a specific provision for annulling transfer made with the consent of the deputy commissioner, recourse must be had to that, and an application under general provision under section 71A is barred. Moreover, as noticed above, the forum is also different. Therefore, my lord, it was held that in case of contravention of section 49, then 49(5) is the only scope. No 71A is liable to continue, which was not taken into consideration by the commissioner. In the earlier commissioner order, it has been taken into consideration, and the issue which was permitted to be raised for the first instance, that was raised, and that was the reason that the earlier commissioner allowed the revision and set aside the order passed in a proceeding under section 71A. It is very specific judgment on this point. And therefore, the proceeding pending before the respondent number 2 arising out of an application under section 71A was passed. This was followed in another judgment, not this judgment. Unfortunately, Lord, I was also one of the lawyers for the case. The case of, this is not 2001. In this case, your Lordship will kindly see, Lord, that paragraph 16, paragraph 15. To that extent that this is a separate program. 1990 BLJ 352 was also referred to
Just a moment.
and relied on. Paragraph 6.
That's right. In a situation, these cases do not cover a situation where the land has been given for a particular purpose and it is not utilized for.
But the question is to the root. Whether the proceeding under section 71 can decide this. This is for
You
only.
see, if the deed is vetted by the commissioner.
Therefore, the remedy, that is the reason the division bench discussed. The legislator 71 है मुझे पहले आया और
Sir,
बाद में
एक
आया
second.
49(5).
Just a moment. Sir. There is a difference between the two, and I know you will appreciate that when the permission is being granted, the permission is obtained by fraud or misrepresentation before the deputy commissioner. So that amounts to fraud on the deputy commissioner.
Yes.
But if the permission is granted for a particular purpose and that purpose is not undertaken, then that is not fraud on the commissioner.
But
Then the fraud is on the Rayyat, because Rayyat had
No.
agreed to the
It has
permission
to be decided.
because
Therefore,
Rayyat had agreed to the permission
Rayyat
because
can
the land was to be utilized for the
But
purposes
that
of
I-
setting
I
up
also-
of an industry
That has not been discussed.
which would
Evidence-
also,
Evidence was not discussed. We have the reports.
it
were
is an
sought.
admitted fact.
That had not admitted.
Yes, yes.
That-
That you did not set up the industry at all, you were constructed
And
house.
certificates we have brought on record, and that is also before this report.
No, no.
Secondly, you also may kindly see whether the scope of 71A can extend to that extent. That is my question.
See,
My-
the point
my-
is, if a property is being given for a particular
But-
purpose
but
and
when
if you
there-
don't use it.
But when there is a
Sahi hai na,
specific,
49.
when there
CAT
is a specific provision under the Act, 49(5), then why it should be
No,
omitted?
no, that stage is different. One is that the permission is not fraudulently obtained.
No.
There is no fraud on the
Even
commission.
violation, you also just read below this division bench judgment. If there is a violation of subsection 1 and 2 of section 49, then 49(5) is the only recourse.
Let us see 49.
Yes, 49, you also just see. 49(5). That is the reason I was relying on this judgment. The recourse is available, remedy is there. And the second judgment, it has been said, when there is a remedy, you have to make a receipt, 49.
You see, in the
49(1).
second judgment, the fact was that permission was
Yes.
granted, the sale deed was executed, and then the recorded reyer, he filed an application that the transfer was effected by an illegal manner. That was the plea.
Yes.
Illegal manner.
Similarly, here also, there are cases that I have illegally got it.
No.
And my purpose was for setting up an industry.
There is
I
no
did
doubt
not
on
set
that.
up.
That was the
That
case.
is, so therefore, that was to be discussed and adjudicated on the basis of evidence.
It is an admitted fact that you are constructing
The
a house over
application
there.
does not say so. Not the yellow side. Just now you
49.
49 per notwithstanding anything contained in section 46, 47 and 48, any occupancy reyer or any member of the Bhunyari family who is referred to in section 48 may transfer his holding or tenure or any part thereof for the following purposes.
ये pre-amendment बताइए ना. This has been substituted by Act of 1996. Pre-amendment
1976.
नहीं 1996.
This is
To substituted by CNT Amendment Act 1996, Act 2 of 1996. आपका तो
1976 में substitute by section 49(5).
76.
49(5).
नहीं 49(2) जो आप पढ़ रहे हैं, 49(1) जो आप पढ़ रहे हैं, that was substituted.
96 substituted by CNT amended at 1996. तो 1996 के पहले
और 5 बताइए.
5 the state government
Date of
may-
permission कब का है?
82.
The state government.
The state government may at any time within a period of 12 years from the date on which written consent is given by the Deputy Commissioner in regard to the transfer of any holding or part thereof belonging to an occupancy reyer who is a member of scheduled tribe, either on its own motion or on an application made to it in this behalf, set aside such written consent and annul the transfer. These are the catching word. If after holding an inquiry in the prescribed manner and after giving reasonable opportunity to the parties concerned to be heard, it finds that the consent had been obtained in contravention of the provision of section 1 and 2 by misrepresentation or fraud. So the consent with regard to grant of permission, it is not subsequent events.
Sir, permission has been rightly granted. But
Therefore,
if a person diverts it
then
and
the
use it for some other
permission
purpose,
has to be annulled, transfer has to be annulled. This is the provision. It is not the eviction. Your Lordship may kindly see annulled. And in case by holding or any part thereof has been transferred on the basis of such written consent, direct the Deputy Commissioner to take further necessary action under section clause C of section 4A. So there are two different provisions. Now your lordship just read section 71A. 71A. In that petition notice was there. I will not read that.
Yeah.
That has been quoted in the original order. Therefore, I glad.
That's right.
So my submission for lordship would be
Sir, with all respect to you, in both the judgments, it is not a case that after obtaining permission, the land has been utilized for any other purpose. ऐसा fact नहीं है.
but with all respect on my
But at the
submission,
same time, we have to decide कि 71 लगेगा कि 49.5
yes,
लगेगा.
that is my only question. That is the only question. And section 49(5) has to be read in between the lines. The lordship will find it is unlike 71A. 71A is violation of 46, number 1. Number 2, obtain a degree fraudulently. Number 3, if the possession was given, not taken fraudulently or misrepresentation. These are the basic ingredients to attract section 71A. Whereas 49(5)(b)(5) is especially for annulment of the order of permission, annulment of the consequential deed pursuant to the permission granted. So there are basic difference, and that is the reason division is very short and concise judgment. It has
On the point as to whether the authority had the jurisdiction to grant permission, you are referring to notifications.
my submission for lordship is that the remedy is elsewhere. That has been laid.
Even if the permission is without jurisdiction.
Yes, remedy is 49(5), not 71A. That is my only question. And that is the question in the division bench.
Under
also.
section 49, who has to give the permission?
That is the deputy commissioner, which includes the additional deputy commissioner. He is the additional deputy commissioner.
Just a moment.
just see. Not
49.
हमारे पास तो रिवाइज वाला नहीं है, रिवाइज वाला modified 96 में. Before 96, of course I have not seen any change, but still I do not know what was the provision 49(1). Notwithstanding anything contained in section 46, 47, 48, any occupancy rare or any member, that is also perverse order with regard to commissioner. There is not a mundari put.
Sir, the transfer is for a limited purpose under the section
Yes,
49.
limited purpose, and that is to be annulled by subsection 5 of section 49. You also just see what is the power and conferred under section 49(5). Within a period of 12 years, on application or its own motion, such written consent and annul the transfer. So it is post transfer, a post permission. The lordship confined it in the permission, not permission only alone, but the transfer. Transfer is the consequential effect of permission. So annul the transfer. If after holding, what is to be done? There must be an inquiry in the prescribed manner. Number 2, hearing of both parties, and then if it is found a consent had been obtained in contravention of the provision of subsection 1 and 2 by misrepresentation or fraud, and in case any holding or part thereof has been transferred, so you all are relating to transfer. On the basis of such written consent, direct the deputy commissioner.
Who had given you consent?
The deputy commissioner, additional deputy commissioner, annexure 1.
And you say that additional deputy commissioner was empowered.
Power. And now, if
Which,
you
where
also
is
may-
that notification?
Now you are also may kindly see the definition in the Deputy Commissioner. And also just see CNT Act, Section 3 defines.
That issue has been discussed in order 22 matters with regard to jurisdiction matters.
Order number?
22
And therefore
dated 9
therefore the circulars were also brought on record. And
Just
they have
a-
admitted.
9/3/22.
matters.
This was, yes, ma'am. 11/1/2020. The order dated 11th January 2020.
9/3/22.
11th January 2020. DC to file counter bid on the point of delegation.
Page 2 plus paragraph 3.
Hmm.
Counter bid was filed in compliance with the order of this note.
So this issue has been decided in favor of the petitioner.
Ma'am.
Yes. They were directed to file counter. The counter was brought on record. They admitted this position.
Okay.
Matters. Here matters the petitioner has played fraud and misrepresentation.
Upon whom?
Matters misrepresentation upon the deputy commissioner as matters from annexure 1 page 20.
If the misrepresentation is upon the deputy commissioner, then in view of the judgment, if the fraud is on the deputy commissioner, then 49(5) will come into play.
Matters
How
fraud
71
has
will come?
been played with the private respondent matters, that is the tribal, by matters saying that the petitioner will use for a specific purpose for manufacturing of tiles and matters pottery matters. And subsequently matters it has been admitted by the matters petitioner matters in his matters counter affidavit matters before the court below at page 26 matters.
Section 9 and 9 by
Page-
1
page-
are not completed in this regard. 9 and 9 by 1, page 49 is the
Page 25 matters last paragraph
for my learned place.
उपयुक्त संदर्भ
Section 9 9 by 1 is this registration certificate.
Where is the deed?
Deed, registered deed is not on, but that is not in this. Section 9 your lordship may kindly see
आप उनको
page
बोलने क्यों नहीं दे रहे? आपसे सुन तो लिया। क्या एनेक्शन 9 में क्या दिखाना चाहते हैं?
registration certificate उसी पर्पस के लिए हुआ, बाद में।
There is no doubt on that. That was the condition
They are
of.
saying that this is 92 में रिपोर्ट आया कि हमारा चल रहा है पोटरी का फार्म। अब उसमें घर बना है, मतलब उस पोटरी फार्म के लिए घर बना है। ये एडमिशन कैसे मान लिए? That is the reason, and no inquiry in this regard.
it has been
Whether
admitted by
they are,
the petitioner.
they are saying that I have admitted. Where is the admission? Let them show
That
where
are
they admitted.
that are so much. Page 25 last paragraph.
My admission, everything will go in my admission. That is not an admission. On the other hand, the petitioner placed before the authority also, Section 9 and 9 by 1. Those are the subsequent 92. That factory is running. How they say that is not factory? And who has reported it?
क्या चीज का फैक्ट्री बनाया है?
Pottery? Pottery लोग मुकार है pottery का
यही कंडीशन था।
मार्च से वो बनता है।
हाँ बताइए कहाँ है?
Matters. Page 25 last paragraph में editors उपयुक्त संदर्भ में प्रतिवादी के द्वारा कारण परीक्षा दाखिल किया जिसमें यह स्वीकार किया गया है कि संबंधित भूमि के एक अंश पर वे मकान बना रहे हैं, परंतु यह भी स्पष्ट है कि धारा 7 के अंतर्गत दी गई अनुमति के शर्तों का उल्लंघन होता है, तो इसके लिए धारा 71 के अंतर्गत कार्रवाई का प्रावधान नहीं। But unless it has been admitted that he is making construction
Deportion.
man portion and subsequently in the
अब
counter
वो
affidavit
एक बात बताइए, वो जो पोल्ट्री बिजनेस करेंगे तो क्या हवा में करेंगे?
no that
कहाँ लिखा है कि अपने आवास के लिए बना रहे हैं? कंस्ट्रक्शन चल रहा है, लिखे मकान तो चार दीवारी से मकान होता है, कोई यूनिट के लिए भी कोई कंस्ट्रक्शन होगा तो चार दीवारी में ही होगा.
that is there. Again, in counter affidavit, it has come that the petitioner has established a bull factory, and he has taken permission for manufacturing of tile, and thereafter, in the name and style of Suman Bull Factory and manufacturing of tobacco product, that is Mrs. Rani Kaini was established in violation of the term of the transfer that has come in the counter.
You see, if a person takes permission and does not utilize it for that purpose, then under such circumstances, the permission can be revoked. The registration can be cancelled. Who will revoke it?
Revoked by the collector.
Collector. He will revoke it under 71A or he will revoke it under 49. यही तो इनका कहना है. 71A में नहीं चलेगा. ये नहीं बोल रहे he cannot do it. The collector or the commissioner can still take an action. He is not saying that. He is saying that such an action, if you see the very act of taking permission and not using it for that particular purpose amounts to fraud at the time of taking permission, because you never intended to do it. And if there is a fraud on the commissioner, then under such circumstances, commissioner will revoke it. He can exercise the power, still he can exercise the power. But 71A at the instance of the Rayyat cannot. Because Rayyat has already, and you see one more thing. If the permission is revoked and the sale deed is cancelled subsequently at the instance of the commissioner, what is the consequence?
Land will be restored to the original tribal.
ठीक है, ट्राइबल को होगा रेस्टोर.
But here the petitioner has played fraud with the
Fraud को इतना lightly मत use किया करें. Fraud is not a word to be so lightly used. There is no inquiry, nothing. उसका reply पर जाकर आप एक order कर देंगे. नहीं चलेगा ना? नहीं चलेगा.
But he has given assurance to the tribals that he will use that land.
कहाँ बोल रहे? आप उसको cancel कर दीजिए. You can cancel it. That right is still open to you. Under 49(5) you can exercise the power, but not at the instance of the Rayyat. Rayyat can bring it to the notice of the commissioner that this has happened, but how will he exercise this power under section 71A?
Because in 71A it has been
71A.
Power to restore possession to member of the scheduled tribe over land unlawfully transferred. If at any time it comes to the notice of the deputy commissioner that transfer of land belonging to a Rayyat or a Mundari Kurkatita, a Bhuiari, who is a member of the scheduled tribe, has taken place in contravention of 46 or section 48 or section 240 or any other provisions of this act,
आगे पढ़िए.
or by any fraudulent method, including decrees obtained in a suit by fraud and collusion, he may, after giving reasonable opportunity to the transferee who is proposed to be evicted, to so cause and after making necessary inquiry in the matter, evict the transferee from such land without
कल ऑर्डर करेंगे. छोटा नोट बना के लाएंगे सर. आप भी ले आइए. The core issue involved in the present case is as to whether the proceeding under section 71 capital A was maintainable or the remedy under section 49 within bracket 5 was illegal. The learned counsel for the petitioner has submitted that the land was transferred after taking due permission under section 49, and the permission was granted with the condition that one unit was to be set up which would also generate employment. He submits that under section 49 within bracket 5, there is a specific provision that if the permission is obtained by fraud or misrepresentation, appropriate steps can be taken to annul the permission itself. He submits that pursuant to the permission, the sale deed was executed and the original Rayat had filed a petition under section 71 capital A of Chota Nagpur Tenancy Act, which was not maintained. He has referred to the judgment passed by Honorable Patna High Court reported in 1990 BLT within bracket RDT 352 in the case of Sri Rajendra Nath Kapoor versus State of Bihar, and also which has also been followed in the judgment passed by this court reported in 2001 with bracket 2 bracket close J8RCR 127 with the bracket JHR. The learned counsel for the respondent has opposed the prayer and has submitted that fraud has been committed upon the authority who has granted the permission
as well as upon the
Rayat, and therefore the petition under section 71 capital A was maintained. The petition, the counsels are directed to prepare short notes. Pose this case for further arguments. कल लिखाएंगे हम इसको, थोड़ा सा देख लेंगे। और कोई बात हो तो बता दें।
आपके दादाजी भी
क्या चीज?
जीवनलाल किराना सेकंड वाला केस।
हाँ, एक हम लोग का वो फर्स्ट अपील है ना, अभी आउट ऑफ टर्न कौन सा करना है? आउट ऑफ टर्न तो मेंशन नहीं हुआ था।
सुपर मेंशन किए थे 4 उसका सीएमपी नोट आईए फाइल के ऊपर डिफेक्ट इग्नोर करने के लिए नोटिस है।
कौन सा डिफेक्ट है?
बट डिफेक्ट है लोग, एक तो कि पिटिशनर नंबर 1 जो है वो पार्टी नहीं है जो रिट में है, जो सीएमपी है वो लिखे है, उनका डेथ हो गया है 2007 में ही, एंड therefore not his sons are seeking leave under chapter 12 rule 96 to pursue this. This is IA number 1531.
Appellant number 2,
Petitioner number 1.
petition number 1,
Yes.
उसका डेथ सर्टिफिकेट
But death certificate है,
नहीं है।
हम सुबह ही मंगा देंगे।
किसको नोटिस करना?
बट खाली प्राइवेट रिस्पोंडेंट को नोटिस है।
पार्टी पोजीशन पर है।
पार्टी पोजीशन नोट जहाँ पिटिशनर के बदले पिटिशनर के बाद पिटिशनर लिखा है, वो हम ड्यूरिंग कोर्स ऑफ द डे रिमूव करेंगे। और प्रोविजन ऑफ लॉ 227 लिखा गया है, 226 होगा क्योंकि रिट पिटिशन है सीएमपी एक्ट से। बट ये रिस्पोंडेंट नंबर 4 to 8 4 to 10
कहाँ आप सारे डिफेक्ट्स रिमूव किए हैं? यू रिमूव द डिफेक्ट्स, हम ऐसे नहीं ऑर्डर।
बट खाली
The learned counsel for the appellant petitioner is permitted to remove the surviving defects during the course of the day. करिए आप post tomorrow. आप अभी करिए, आप रजिस्ट्री में भेज दीजिएगा, समझ रहे हैं? उसको फ्रेश रिपोर्ट करा के भेजिएगा। खाली आइए रहना चाहिए तभी करेंगे, नहीं तो नहीं करेंगे। हाँ, वो फर्स्ट अपील है। नहीं, फर्स्ट अपील हम लोग रखे हैं। देखिए इतने सीनियर बैठ वेट भी कर। आइए सर, आपका मैटर। वो गलती से ना 10:30 बजे वाले बोर्ड में रखा। आप फर्स्ट अपील में हैं? अच्छा, कोई आप कल परसों जब भी हो। हाँ, यस मैडम, दिस इज योर What is it?
ये कल लेडी से जमा किया गया है लेकिन वो आर्गुमेंट
कौन फाइल किया?
रिस्पोंडेंट
Responding. ठीक. कुछ नहीं, इतना पुराना केस में आपको अचानक अर्जेंसी कहाँ से आ गया?
पेमेंट नहीं हो पा रहा है
कोई बात नहीं, अगला हफ्ता अपने आ हमको तो अपने कल का नहीं पता. नेक्स्ट वीक आएगा, आ जाएगा. यस मैडम. देखिए ये वाला मैटर टेकअप किए, इसको खत्म करना चाहिए. हो सकता है अगर आज नहीं खत्म होगा तब कल के लिए. दिस हैज टू बी ओवर नाउ. यस मैडम.
Actually, I will be just addressing this on issue wise
Okay.
and each of the issues with the judgment and proof.
That's it. First issue.
First issue is burden of proof that I argued yesterday
Okay.
also later. The judgment.
Burden of proof.
Yes. Is
You have cited the judgment.
Yes.
I just-
2013,
2013,
volume 14,
volume 14, SCC
50.
50. Okay.
Relevant para was 9.
Parallel. Done.
Wherein it says that the claimant has come before
Yes,
the court
please.
for enhancement.
Fair enough. Number 2.
Number 2, in this only I would refer to the evidence circular 101, 101, 102 and 103. Burden of proof.
101,
101 is burden of proof. From where it starts. Number 1, 101 is marrying.
like evidence and प्लीज आपको वो जर्नल मिला? One zero one. Okay. Yes, please.
Whosoever desires 101 I am reading your edition and 103 will be the most relevant. However, everywhere it says, whosoever desires any court to give judgments as to any legal right or liability dependent on the existence of fact, which he asserts, must prove that those facts exist. When a person is bound to prove the existence of any fact, it is said that the burden of proof lies on that person. Now, leadership 102, on whom burden of proof lies. The burden of proof in a suit or proceeding lies on the person who would fail if no evidence at all were given on either side. On either side. And third is 103, burden of proof as a particular fact. As to particular fact. The burden of proof as to any particular fact lies on the person that wishes the court to believe in its existence unless it is provided by any law that the proof of that fact shall lie on any particular person. So in all the, whether it is 101, 102 and 103 which covers all types of cases, one who approaches the court, the burden lies on him, whether any evidence is led by both the sides or not. Ladies, my second limb of argument is, different market value compensation can be determined for different lands located differently in the same village. Even if the lands are in the same village, different land attracts different compensation. Here, my lord, in this particular case, as I have shown from the map also, my lords, these are all the lands situated somewhat nearby or distantly located to the concerned land, my lord, at Pindra. Now, the judgment I am relying upon, leadership, is civil appeal number 2732 of 2020. Para 13 would be relevant edition. Same village, different location, different compensation. Para 11 deals with the development cost, which I will be dealing separately as well. However, it has been taken care of in this judgment as well. Para 30. At page 22. Now, so far as compensation determined differently for different lands acquired with respect to the same village, Boyar, ranging from rupees 1,50,000 per hectare to rupees 2 lakh per hectare is concerned. Different market value compensation can be determined for different lands located differently in the same village or locality. In the case of Trilochan Singh Sutra, it is observed and held that it is common knowledge that all the lands in the same village may not possess the same quality and command a common market price. Below one which is situated near the highway or some other that kind of that increase or some factory or some near the mine, that would obviously attract more compensation than the one located distantly from those places. Now, several villages have been acquired by the same notification. However, one village, Layo village, which is distantly located from Pindra, that has been considered, which has not even acquired by the same notification. And based on that judgment that has been passed by the Honorable Court with respect to Layo village, here the compensation has been decided on the flat rate of 600. Lord, in this judgment,
Wait a second. This Layo village was not acquired by the same
No, no.
notification. How do you spell Layo?
L-A-I-Y-O.
Layo village not acquired by the same notification.
Yes.
Exhibit the kind.
नाप भी देखा जा सकता है एडिशन
नहीं नोटिफिकेशन देखेंगे आप बोल रहे हैं सेम नोटिफिकेशन से नहीं
नहीं इस नोटिफिकेशन से लेडीशिप द विलेजेस दैट हैव बीन एक्वायर्ड दैट लेडीशिप हैड टू द पर्टिनेंट क्वेश्चन yesterday these are गोविंदपुर इंदिरा भुसरी भरेरा कजरी पिपरा दारू कसमत रोता पिंडरा तापिंग मांडूर केके बसुंदी कुंडी परेश but not Leh. It is at page number 12 exhibit of CCL. Page 12.
Yes.
Exhibit of CCL, all the villages that have been acquired, that has been mentioned. Barabutti and Manji.
You see page number 7. You have got a copy of that? Just a minute. So, yeah, page number, internal page 7 and running page 8. Layo. 895. Serial number 3. Block 3.
Yes, leadership Kedda.
नहीं गालिकिया एलियस केदला एंड लोहिया
One page number 12, if leadership sees.
No, but it is also the same thing. But the same, it is your exhibit, isn't it? These are all your exhibits.
Consolidated list is given. However, leadership might have missed this one.
Okay, no problem.
Yes. Page 12 with consolidated list of all the villages that have been acquired. Even otherwise, 600 rate has been considered taking Laya into
In the judgment of Layo, the date of notification must have been mentioned.
वो that is from different notification. Layo वाला जो exhibit 1 है on which relying upon the same the
Which is the date is the same?
No, notification date is different. वो 80 या 81 था, this is 80.
This is 83.
80 yes.
So that judgment is also of a different notification.
Different notification.
Okay, let's see that judgment which is at exhibit.
Exhibit 1. Starts from page 2.
Yes, yes.
It is, shall I read from the beginning edition?
You just show me the notification. That should be sufficient. Notification dated, published in Gazette, notification, 1980 notification.
1980. And here the notification is notification dated under section 431
325 acres of land was acquired.
different notification.
Yes.
So this is related with respect to a different land.
So exhibit 1 could not have been relied upon.
It had could not.
But exhibit 1 is not to be relied upon.
Yes.
But we can also consider is that if there is any other material. We are in first appeal.
Yes, relation is
So exhibit 1 relied upon is absolutely
yes.
not proper. Date of notification is also different. Okay. That's
Now exhibit 2.
exhibit 2.
Yes. These are the lands which have been acquired with the same notification. Here, the court below has modified the award below, and that has been mentioned in the agreement judgment as well.
Exhibit 2.
Yes. Judgment के para 12 exhibit 2 has been mentioned.
Exhibit 2 is by Additional Judicial Commissioner.
This is the photocopy of the certified copy of the judgment passed by the tribunal on 1/3/94 under CB Act in respect to 16 reference cases related to the lands of Pareg and Daru Kashmir.
That's true. Same notification.
Same notification. And considering all the evidence, including the sale deeds produced before the tribunal, flat rate of 72,700 per acre was granted by the enhancement of the compensation awarded in respect of the acquired land. So in exhibit 1, it was given a flat rate of 600 edition. Here, 72,700, so 727 per decimal was decided. However, 20% deduction was made towards the development cost.
In that case, it was 600
It
per
was
decimal.
per decimal. Exhibit 1.
Exhibit 2 is
Exhibit 2 में the court below has decided is 727 per decimal.
at flat rate
No, 20% deduction. Flat rate against all the lands.
against all the lands. Classification has been done.
Classification is done. Ladyship, one thing I would like to submit here, I tried to find out. This order was further challenged before this honorable court in MA.
Amen.
MA 50. MA 50 of 1995.
Yes, what happened?
And that was decided on 10/11/2004. Compensation was reduced again to 600, keeping all the other parameters same. I could not find the judgment. It is not available on record.
इसका फाइल मंगाई. Reduced to 600. So
600.
at par as lawyer.
As yes, this I am just making submission. I do not.
Yes.
We have received the
We'll get
instruction. We had asked
We'll get
about. Yes.
So for lawyer also
Layer also 600.
600. For
Here
these
also
two also 600.
But
And in
with
this-
20% development cost reduction.
Okay. 20% was deducted. Why on development charges when it was being acquired for mining?
Yes.
Why? Because you see, you have been relying upon a judgment passed by Honorable Justice Ananda Singh, where he said that when the land is acquired for mining purposes, there is no question of deduction on development charges. Correct? So,
In this it was the
in this it
High Court
was
in the High Court had reduced 727 to 600 flat rate. $727 to 600, keeping all parameters the same.
and you see, this was reduced to 600.
600. That was also 600. This was also 600. Keeping other parameters intact.
So why should we interfere with 600? In this case?
I should be fair enough with
Yeah.
this honorable.
I appreciate
so what
that.
I could
I
gather,
appreciate that.
what I couldn't gather during my reading was the judgment myself, so I knew that the honorable court would get the file. But this is the fact. Now, in addition, my third contention would be it is with respect to development cost. The development cost, I am relying upon two judgments. ये same village, different compensations and they given this is the judgment petition, which I was relying upon. Civil appeal number
You
2734.
see, you have also not given different compensations. You have just classified the land
Yes, it does.
on the basis of location wise or any peculiar feature of the land. Nothing has been changed. You have just classified the land and given the compensation, irrespective of location,
Yes.
irrespective of any other advantage. So these judgments, there are consistent view in these judgments, and this particular land has been also acquired by the same notification for the same purpose. This was also for the purposes of mining.
Yes. CD Act means
Huh.
so under CD Act is mining, land
Yes.
acquisition and for other purposes lands are.
So इसमें 20% डिडक्शन है और हमारे वाले केस में लैंड एक्विजिशन.
ये नहीं हमारा केस भी CD Act की.
This first appeal is arising out of CB Act.
Yes. CD Act से Exhibit 2 CD Act से है same notification this land and Exhibit 2 727 was reduced to 600. Keeping other parameters the same.
Okay. And also deduction of 20%.
Yes. Keeping other just the amount has been reduced. Keeping other parameters.
That's all. The development cost का judgment.
Development cost की judgments limited. I am not be placing so much. From the order impugned order, no development cost has been deducted. So the judgments I am relying upon is 2009, volume 15, 767,
2009 volume 15 SCC
767.
767.
Here in para 22, it has been held development cost may vary from 20% to 75%. And the second judgment edition is
Nee, what was it? This is Patini.
This is Lalchand versus
This was acquisition for what purpose? Housing.
land acquisition.
Housing.
Housing land acquisition. And next judgment is, this is also land acquisition, 2018, volume 2, SCC 474.
2018 volume 2 SCC 474.
इसमें लेडीशिप आफ्टर कंसीडरिंग एवरी फैक्ट कि 20 से 75% हो सकता है, 1/3 डिडक्शन हैज बीन मेड इन दिस पर्टिकुलर केस. रेलेवेंट पैरा 9 and 10, 8, 9, 10. एक लेडीशिप का जजमेंट है FA ये भी LA केस था ना, FA 71 of 2015. इसमें पैरा 38 में leadership had taken the average of all types of the rates considered for all types of land and taking the average a rate was decided.
That's right, because there was उस जगह का कोई रेट नहीं था.
जी.
ठीक.
So
तो यहाँ तो एवरेज का तो कुछ लेने का स्कोप नहीं है.
other
Because we have only one, wait, same notification का, you see, two, 3 things are very very clear. अगर same village का मिल जाता है, we will not look into another village. Simple. अगर same village का मिलता है, different notification है, that can be considered. Same village का मिल जाता है, same notification है, that is the best evidence. Correct. In case there is absence of any sale deed of that particular or any document or any evidence of that particular village, what we can consider is adjoining villages
yes.
or even those villages which has been acquired by one go.
Yes.
This is the basic principles. Right? Same village का है नहीं. अब adjoining है कि नहीं है, that is a map से we have to see. दूर है but acquired by the same process. Notification भी same. And acquired for the purposes of coal mines. Right? इसमें तो कोई dispute नहीं है.
Judgment ये भी कहता है leadership the purpose for which the land is being acquired that may not be seen by determining the compensation. It is the loss is with respect to the land and they can be compensated with respect to land. Whatever may be the purpose for acquisition.
That's right.
That
Whatever
will
be the
determine
purpose
the
of
land.
acquisition, but when it comes to deduction on account of development cost, it becomes important. Because when the property is being acquired for housing purposes, a large portion of the land goes for roads, other developments. So what is available with the buyer is only small portions of land and around huge portion goes for all these developments. But as I told you, in the judgment passed by Honorable Justice Ananda Sen, he has said that when the land is acquired for mining purposes, there is no question of deduction on account of development charges. And that judgment has become final.
Leadership has yes.
So that is a view of our court. I have to follow it. We also have to follow it.
And next is leadership had again put a very pertinent question yesterday was the circle rate. Yes. Now this is a judgment.
Is it on circle rate?
It is based on the registry office and the decision taken by.
You see, this document, Exhibit D, has not been exhibited by any witness. After the conclusion of hearing, just one day, just part heard matter, it was placed on record and marked exhibit with consent. So there was no occasion for anybody to cross-examine. The exhibit D has just been placed on record. I was looking at the order sheet. I was looking at the evidences as to who has exhibited this document. And this document by itself is not referring to any sale deed.
It has mentioned that the competent authority
What
and
competent authority?
the registry records, as per the registry records, the value of and the
And it is
declaration
not
as-
referring to any sale deeds. Normally we have seen the rate chart. There is an elaborate discussion as to these sale deeds have been taken into consideration. This is the area, this is the thing, this is how the calculation is made. Firstly, there is nothing on that, and the way it has been exhibited, it has not been exhibited by anybody. It has been simply marked as exhibit.
However, the judgment that I am relying upon is 2024 SCC online SC 1691. This is the judgment. Just because it is a long judgment, I have put
Para
flag. In para 14, the argument has been advanced that circle rate does not reflect the market rate, and that has been decided in para 42. It says compensation can be determined applying the principle of guesstimation based on circle rates after granting marginal increase over the same. That is at para 43. I have put the flag there.
Yes. So some guesswork still has to be done. in spite of circle
Yes,
date.
some increase.
Some kind of indication you can have from circle date,
Yes.
but still some guesswork
Yes.
is required.
Estimation they have used it. And
Guesstimation?
leadership has also decided the same.
I have heard that guesstimation has to be done on the basis of some material of it. It cannot be without any material.
It has been laid down that compensation can be done applying the principle of guesstimation based on certain rates after granting marginal increase over the same
That's
as it reflects the market.
that's
Leadership has also decided the same जो 400 अभी जो वाले डिसाइड किए थे leadership पैरा 113 at page number 3.
क्या फर्स्ट अपील नंबर क्या है?
First appeal number is 492 of 2000. One of the tag matters is 492 of 2013. Orders start from page number 239.
पार्टी पोजीशन होता है.
Party position to 115 है. And thereafter at para 113 leadership at page 337 जहाँ से 114 शुरू हो रहा है उससे 3 लाइन होगा. उसमें exactly same it has been observed by leadership. First है 367 of 2018 जो first matter है इसमें.
अच्छा 367 of 2018.
जी. With other announcements. इसका para 100.
This is what the Honorable Supreme Court has said. That some guesswork is permissible, but it has to be based on some material. It just can't be in air. So for the purposes of guesswork also, we have some material. We have some
रेट
material.
उसमें लिया गया
हाँ.
कि whatever rate the government has decided उसमें आप कुछ guesswork करके आप थोड़ा सा increase करके दे सकते whatever the government has decided. Now leadership interest part, that is interesting. Here the interest has been granted from 1981 itself.
1981.
Yes,
That
from
is
the
the
date
date
of
of
notification. Now leadership, if we come by with CB Act, CB Act section 17(3).
Yes.
It says when the amount of compensation is not paid or deposited as required by this section, the central government shall be liable to pay interest thereon at the rate of 5% from the time the compensation became due until it shall have been so paid or deposited. Now, leadership, because this was only 5% that was considered in the CBA. So, land acquisition where detailed interest part has been taken care of. So, even in the CB Act, the interest part of acquisition, land acquisition
Has been applied.
incorporated. Now, coming to the interest part of land acquisition, and obviously this 5% is too less leadership, so it has not been considered and it is not being followed. Section 34 of Land Acquisition Act.
Yes.
Now shall I read it? Yes. When the amount of such compensation is not paid or deposited on or before taking possession of the land, the collector shall pay the amount awarded with interest thereon at the rate of 9% per annum from the time of so taking possession until it shall have been so paid or deposited. So the interest has to be given from the date of possession, taking possession. Leadership consistently इनका खुद का deposition है.
That they continued in possession.
1996 इनको possession मिला. 1995 में इनका compensation दे दिया गया and thereafter possession was taken in the year 1996. Now it has come on the surface here from deposition witness number 1, Jhan Manji. It is page 11, para 5.
EW1. Page 11, para 5.
Yes. इसमें कहता है 1980 के बाद कब्जा 1996 में लिया गया. Thereafter leadership same statement by TW2 or claimant witness number 2, para 3. 1996 में कब्जा लिया. So it is an admitted fact leadership that and though the land was acquired long back, the notification was of the year 19.
Physical possession was
Physical possession 1996 में लिया गया और उसके पहले 1995 में इनको compensation दे दिया गया. That would get evident.
So you want to say that there should be no interest?
नहीं, जो अभी जो enhanced rate रहेगा,
हाँ.
उसमें जरूर interest रहेगा. That is section 28.
वो कब से interest है?
वो रहेगा from the date of possession till the payment of the enhanced rate. Section 28. This is the act itself says so. May I read out?
Section 28 of the
Land Acquisition Act.
is Land Acquisition Act ipso facto applicable in this coal clearing act?
Leadership, only this interest part that has been adopted for because उसका तो 5% interest ही था. तो ये जो 9%
कोई judgment है इसका?
एक सुप्रीम कोर्ट का जजमेंट था. I'm not sure, but I had written somewhere. I'll give that. It is somewhere in my notes.
So interest is a contested point.
Interest is a contested point. The
Solation no issue.
solution भी नहीं है लेकिन solution भी consider करके दिया जा रहा है. So my contention would be that solution should not be given, interest 5% beyond that cannot. But now this has been harmoniously, it has been adopted. But
And consistently applied.
consistently, solution and this interest 9% and 15%. First year के लिए 9% and thereafter 15%. But from which date it is admissible? From which date it has to be given? That is section 34 that I just read, and the enhanced compensation, the section 28. May I read out? Collector may be directed to pay interest on excess compensation if the sum which is in the opinion of the court the collector ought to have awarded as compensation is in excess of the sum which the collector did award as compensation. The award of the court may direct that the collector shall pay interest on the excess at the rate of 9% per annum from the date on which he took possession of the land to the date of payment of such excess. Now the reason behind it from taking possession, because though the notification is of that year, the claimants they have been enjoying the land. It was not in the possession of the government that they were not enjoying. So the interest part would come from the date of possession from which they have taken, and it has been incorporated in the act itself.
That's so in the other cases where this development cost has been imposed, the other case where it has been done, there the interest
The
and
acquisition in this also it has been held from the acquisition.
in the other cases
In other
also from the
cases
date
also
of
the
acquisition.
acquisition, maybe this particular the provision has not been properly based, for the appreciation of the honorable court or the other honorable court. So I'm just placing it.
That's right.
That's all. Leadership, and today they have handed over two, may not be called applications, but they have brought to the notice that some persons have died.
इसका क्या
And they have just handed it over to me today.
इसका क्या मतलब है सर?
So these
We are not in that.
Sorry?
That is in 1st April 6 of 2014 leadership.
all the matters are being decided together, leadership, and this is what
ये बिना affidavit के ये सब का कोई मतलब नहीं है. We will not take it.
Some other council.
We will not take it like this. Somebody has to come and say, no? ऐसे कैसे? Because some other council will throw a page. ऐसा नहीं.
I'm just bringing it to the kind notice of the honorable court.
I do not know. Council is also not here to say. The council is also not here before us to say this.
Subject matters.
He is not here.
This has been handed over to me just before the case was closed.
He is the respondent.
Yes, he is the respondent in one of the matters, 6 of 2000. Same judgment leadership, in all the matters, everything is same. Only the village name has changed by the compensation.
Nothing has been brought on record as to Who has died when?
Nothing,
Who are the
just
legal
information
heirs?
addition to me, so I just brought to the kind notice of this.
And he has
And
left
it
the
has not been filed also, no affidavit.
सर एक दिन और आपको कष्ट देंगे कल से आप नहीं कल ही सर कल 2:15 सर आप बताइए कौन सा टाइम आपको करनी जी नहीं 2:15 बजे रखिए हम जानते हैं सर। थोड़ा सा दिक्कत तो है थोड़ा सा पहले 2:15 बजे रखते हैं ठीक है जब कल हम एक मैटर रखे हुए हैं उसके बाद पता है वो डिक्टेशन होने के बाद नहीं हो पाता है सेकेंड अपील आपको पता है 84 का सेकेंड अपील 68 जजमेंट्स हो चुका है तो आप समझ रहे हैं क्या चल रहा होगा उसमें tomorrow at 2:15 as first case 2:15 बजे 2:15 बजे सर ठीक है
The council has come Delhi, who had handled the
Actually, my case is directly covered by your Lordship judgment in my annual submission, relying on the judgment of the Supreme Court 2016. Hello, sir, the judgment which, hello, sir,
Which
I am
judgment?
giving for Lordship kind consideration your Lordship judgment. Lordship may kindly go through this judgment, para 40 and 49 of this judgment. This judgment given by our Lordship. Our 48 and 49 of the judgment is very even on the basis of guesswork, the compensation can be awarded. But in my case, it is not a case of guesswork only. Rather, on the basis of the documents and the materials available in the record, which has been mentioned in para 12 and 13 of the judgment passed by the tribunal, and the compensation has been fixed.
the arguments have
to
been
point out, I don't think I need to, my friend has said that again they are giving 1 by A, whether they have preferred appeal and some order has been found. But if the tribunal has said that no appeal has been preferred,
we'll find it out केस का नंबर दिया हम तो रिकॉर्ड मंगा
हमको बस
लेंगे
इंस्ट्रक्शन हम भी ढूंढ लेंगे डिवीजन
हम तो रिकॉर्ड मंगा लेंगे ना सर कोर्ट का रिकॉर्ड है कोई दिक्कत नहीं है
कोई दिक्कत नहीं।
कोई दिक्कत
लेकिन ट्रिब्यूनल ने लिखा है कि कोई अपील नहीं
उस
पाएगी।
समय तक नहीं हुआ
उस समय तक नहीं हुआ
Leadership only liberty for rebuttal for some minutes.
you'll have it the arguments have remained inconclusive for further hearing tomorrow at 2:15
Lordship has also considered this judgment in recent that batch matter 400 cases batch matter.
उसमें दिमाग खराब हो
उसमें कृष्णा
बस यही हम खुश है कि वो अपलोड हो गया
Krishna Kumar versus Union of India.
Krishna Kumar case
Krishna Kumar.
2015 Supreme Court by Lord have taken.
उसमें क्या किए हम
Krishna Kumar.
उसमें क्या था उसमें हमको याद
That is 2015, only 15 Supreme Court cases, page 220. The judgment which has been referred by my learned friend, that has been taken by your Lordship in 2025 in the case of
The Union of India versus Birindam.
गेस्टेशन पर
हाँ,
वो तो आप दिमाग एकदम सेटल्ड है उसमें
356 case का judgment
Such a case.
कौन कौन किया
Union of India versus Birindam आपको में जिसपे सीनियर एडवोकेट है जिसको B&A
अच्छा वो तो 400 केसेस वाला
400 cases वाला
आई वाज सो वरीड जजमेंट अपलोड भी होगा
Substitution होते होते तो परेशान हो गए थे
आई नो लेकिन काउंसिल से बहुत कोऑपरेट किया उसका डिस्पोजल के लिए दिस मच आई मस्ट एक्नॉलेज lot of cooperation from Union of India also and from the private respondents also every day इसमें substitution होते ही रहता था
tomorrow 2:15.
जी सर